Hey YouTube family, it's Humberto from GrayLaw TV, and we're going to do something special for you today. Courtney and I, Courtney, my senior attorney and my YouTube partner, we spend a lot of time answering your questions. What we're going to do today is we're going to make a compilation of frequently asked questions. During our videos, we spend a lot of time on the comments answering your questions. So, get on the live chat with us. After the video, we're there to answer all of your questions. We also have something new on the front of our page. If you go to the link Frequently Asked Questions, you'll see the questions and you click on and you'll go to our favorite videos that will provide the answer. Hey, thanks for watching GrayLaw TV. Click below, like, and subscribe.
First, and the most important, are your tax returns. They want to see that you are filing as a married couple and you're filing jointly, okay? And they want to see that for every year since you've been married. So make sure that you don't file your tax returns married filing separately or file them individually. You have to file tax returns as a married couple filing jointly, and then have copies of those that you can then submit to USCIS. Number two, where do you live? Do you own your home? If so, I would recommend that the deed be in both of your names and that you own it together, right? If possible. So submit documents, your mortgage, etc., showing both of your names on it and that you both own this home. Do you rent your home? If you rent your home, they want to see a joint lease. Sometimes this is difficult, right? Because you had a place, she moved in, she's not on the lease. And so if you can get an amendment to your lease, that would be great, showing that the landlord is aware that you two both live there and that you're living together. If you can get a new lease, great. Sometimes it gets tricky with landlords. They want to up your rent or whatever the case may be. For some reason, you think you might lose your apartment if it comes to light that this person is living with you, and you don't do anything that's not safe for you and your family. You don't have to submit all 9 of these things that I'm saying. Submit as much of them as possible, and if the lease is a no-go, the lease is a no-go, okay? Don't do anything that would be damaging to you or your family or compromise your housing, okay? If you live with your aunt or uncle, get a letter from your aunt or uncle. I own this house. Here's a mortgage showing that I own this house, and my nephew and his wife live with us, okay? So just something showing through the mortgage, through the lease, through a letter with whomever you live with, that you two live together. Whether you're separated or not, you may not translate for each other, okay? So you could take a friend to translate for you. Sometimes USCIS will use a dial-in service if you don't have a translator, or they'll ask somebody in the lobby, hey, does anybody speak whatever language and can translate for this couple? So it'll be a third-party translator if you take a friend with you, or a family member, something like that. So if you do that, that person has to be a U.S. citizen or a legal permanent resident. They have to show their passport or their green card, and they can only translate. It's so hard when somebody asks a question and you translate it and they don't quite get the answer and you want to help. And so you're like, oh, their address they're asking, or you start speaking instead of just translating. The officer could get grumpy. So make sure that you're just translating it and that you've explained to the person that they are only to translate, okay? And sometimes people get nervous and they start making jokes or they start interjecting, which is going to prolong their interview, and officers don't like that either because they have a long day, okay, and a lot of people to see. So somebody sort of professional and can walk in with you. Otherwise they'll help provide one for you. Typically what happens when you walk in the room is the officer's going to swear you in, so don't sit down right away. They might actually tell you which seat to sit in. They might take a fingerprint, they might take a photo, and then they'll go through the forms, the I-130 form that you submitted and the I-45 form that you submitted. So make sure you go through all of those and know all of those questions really well. They're going to ask you if you're a communist, if you're a terrorist, if you're here to overthrow the government. They have to ask you all of these questions. Your dates of birth, they're going to run through the entire form. So be very familiar with answering all those questions. Some of the questions are really long, so don't interrupt them. Let them get to the end of the question before you answer it. We're going to start with the juicy stuff, where they start asking you questions about your marriage.
And question, like, what should they wear? Because even today I didn't know what to wear. So
Oh, you didn't? Okay.
So what do you
that's
wear?
a really good question, like what to wear. You don't want to walk in like a three-piece suit looking like a lawyer, okay? Like I'll be wearing, if you have a lawyer with you, they'll probably be in a three-piece suit. You want to look, you also don't want to wear like cut-off shorts and like a torn t-shirt. Something in between. I would say like business casual. I would say what you have on is absolutely perfect. Something that you would wear like to like a nice lunch with people you want to impress. The sponsorship thing is a myth, meaning it's not true. You don't want to take a sponsorship letter. You want to show ties to your home country. The stronger you show your ties are to the United States, the more likely they are to deny your visa because they think that you're planning on immigrating here permanently. You should be able to show bank statements showing that you have money in the bank, that you can pay for your flight, that you can pay for your hotel, or if you're staying with relatives, like, I have a free place to stay because my aunt is there, or what have you. But I wouldn't take necessarily a sponsorship letter with somebody saying I'm going to sponsor him and I'm going to give him financial support with their bank statement. I wouldn't do any of that. Now, if you're a young person and you're traveling to the United States for a couple weeks to visit an aunt and your parents are going to sponsor you, your parents who are in your home country, that's cool to show. You're 20.
Sure.
I mean, they don't expect you to have tons of money. So yeah, my parents are sending me for a short visit, and then you could show your parents' bank statements, but also show that you have ties to your country, that you're enrolled in school, that you have a job, whatever the case may be. Be sure to check out the B1, B2 video for that one, okay?
Yeah, we just did a segment on the 5 common mistakes at a B1, B2 interview. Mm-hmm. That's the number one mistake, the invitation letter. Don't bring it.
Yeah.
Don't bring it.
Yeah, I don't know why that's so prevalent out there, but
it's just a big myth.
Yeah.
And it's circulating.
I think that it's really important to be polite, to be personable, to be organized, to know exactly what they're going to ask you or what they're likely to ask you so that you can have answers prepared in the way that they like to hear it. They have a long line. They just want to get through it. And if you're disorganized, even if you qualify for the visa, or if you're rude, they'll deny it because they can't get to the information that they need.
It's one person per petition, and there's no following to join. That is a simple concept that will help you with immediate relative petitions. That's one person per petition, no following to join. That's my rule of thumb. That's how, I teach my staff, on these petitions. It can get really tricky. And so I'll give an example. So this is a real case. This is what happened. The client comes to me, they had filed the petition on their own. It was a U.S. citizen husband who filed for his spouse, and there were 3 stepchildren. Again, usually the petitioner, brings in the spouse with the kids, and the kids happen to be stepchildren because they're not his natural kids. Otherwise, the kids would have had green cards already, etc. So he comes to me and he says, Humberto, the interview was last week at the U.S. consulate, and I thought I had applied for everyone. Well, what he did is he filed one I-130 petition. He did include the names of the kids on the back of it. And then he processed through NVC. And at the interview, the family thought that everyone would get the green card. Guess what? They did not. The 3 kids did not have their own petition. The petitioner, the U.S. citizen husband, needed to file 4 petitions. One for the spouse and one each for each of the children. People don't understand that. So the concept of following to join is usually it's in connection with preference petitions and employment-based petitions. That means children under 21 come in under the parent's petition and you don't need a separate petition. But that's not the case for an immediate relative. Okay? Children under 21, stepchildren under 21, they need their own petition. So what's important about this, both on the family and the employment, there's a final action date, okay? That's A, final action date. And then for employment, A, final action date. For all intents and purposes, it's the same idea, okay? What it is, this is when your priority date will become current. At the end of the day, this is the date that you're going to get the green card. When this date gets to your priority date, you're going to get the green card. We got an example coming, so don't worry. Let me just generally explain first. You have filing dates. All right, now filing dates are composed of two things. One date is for consular processing, and the second date is for filing an adjustment of status. Why is this so important? Because usually filing for consular processing, by the time you're eligible to file and by the time you have your interview, it takes about, I would say all said and done, about a year. So if you look at the dates and you're up to date on when you can actually start your NVC process, you can start that. So hopefully by the time you get your interview at the U.S. consulate, the case will be current under the final action chart. And most people believe that if the petitioner dies on an I-130 petition, that's it. You can no longer get a green card, okay? Well, that's not true. So this particular case was very interesting because I filed the adjustment under what's called a humanitarian reinstatement. There's two ways to do it, right? The first way is through what's called a humanitarian reinstatement. You just have to show positive factors, negative factors. You have to have an affiant in the U.S., and you can file your adjustment. Now, immigration was confused. There's another section of law for humanitarian reinstatement, and that is under 204, Section 204. Now, Section 204 requires that the beneficiary, the person that's getting the green card, that they be in the U.S. at the time of the petitioner's death. Under the humanitarian reinstatement, there's no time frame. I mean, my client actually came from Peru on a visitor visa. The parent had died years ago because it was a family third-based petition and it took a long time to adjudicate. So they were in Peru when the petitioner died, came to the U.S. on a visitor visa. We filed the adjustment. Now, here's the interesting thing. At the time of the interview, that's when the officer exercises discretion. It's a discretionary petition. So what happened in this case was we filed the adjustment. There were a few RFEs because immigration was confused over humanitarian reinstatement versus 204. My client was actually scheduled for an interview right before COVID hit. The interview was canceled, and just last week we received the approval without an interview. The green card came. There is a myth going around that K-1s are subject to this new executive order where there's a pause on certain non-immigrant visas and immigrant visas, both family preference category visas, as well as employment-based visas until December 31st. Well, let me tell you, let me dispel the myth right away. The K-1 is not subject to the executive order. So I don't know where this is coming out of, but there's many questions, with respect to, well, we're going to have our interview at the U.S. consulate, but we're not going to be able to come to the U.S. Because of this ban, because of this executive order. Actually, I call it a pause. I think this executive order is a pause because it comes to an end. It's not going to ban visas altogether. So that is a myth. So let's dispel that right away, all right? So what happens with the K-1 visa? Generally, the first step, very simple, right? Most people file their petition with USCIS. In about 8 months, the petition is approved. So that's pretty straightforward. Where it gets tricky is after the approval. So the approval petition then goes to the NVC. The NVC is responsible for processing these K-1 petitions to get to the interview at the U.S. consulate. Now you'll notice on the approval notice of the K-1 visa, it gives 4 months to have the interview at the U.S. consulate. So it's very tricky, right? You don't have a lot of time. And when you're dealing with bureaucracies, there's always delays. So what I recommend is that you put a tickler after the approval for 30 days. You don't, because the file has to go from USCIS to NVC, so you want to give it a little time. I would say 30 days, put a tickler, and if you haven't heard anything from NVC that they've sent the case to the U.S. consulate abroad where the interview will take place, then you make an inquiry. You know, you want to be proactive.
The thing that slows down cases the most is when you get a request for evidence. That's something that everybody calls an RFE. So when people are talking to you about RFEs, they're talking about a request for evidence or a notice of intent to deny that people call annoyed, or just a flat out rejection. You know, a lot of times USCIS will look at the initial filing, think that it's so deficient that they'll just send it back. So the first thing that I would tell you is to make sure that you have everything they want in the initial filing, every form that's supposed to be there, every document, all the supporting evidence, that you send it to the correct place with the correct fee. Okay, and I'll be giving you some resources to help you do that at the end of the video, okay? And USCIS online has a lot of checklists now. So if you were to Google I-130 checklist, USCIS, and the first couple of results that you get, it'll take you to the USCIS website. Make sure that you're going to uscis.gov and not some random person's checklist, right? And there's a checklist there that you can go through item by item to make sure that you have everything there for your I-130, and they have that for a lot of forms now. So make sure that you check that out. They send you an RFE. It takes time. It stops the clock for them. It takes time to get all the documents together and send it to them, and then they get like basically a new clock. So it could really set things back quite a bit, okay? So make sure that all your documents there, everything is in order, that it's all sent together all at once. If you do get an RFE, you know, respond to it as quickly as possible, or annoyed, respond to it as quickly as possible. If you get a rejection, figure out what went wrong, pay close attention to why they say that they're rejecting it, and then assemble it as quickly as possible and get it back out, okay? And that way the clock will start running again, and your case will be processed a little more quickly.